Welcome everyone to this new episode of the Privacy Rules, Privacy Espresso series, a series where we delve into the latest news on privacy and data protection from all over the world with the expert of the Privacy Rules Global Alliance. We do our podcast together with those experts depending on where things are happening. And today with me, I have Stephan Mulders from the law firm based in the Netherlands, Van Diepen van der Kroef Advocaten, with which I'm very pleased to speak. So first of all, Stephan, thanks a lot for being with us.
Hey, Alessandro, it's wonderful to be back with you so soon again. Last time I was at your podcast was a few weeks ago, but now thanks to our trigger-happy Data Protection Authority, we can talk again.
And it's our pleasure. And indeed, it seems like, your Data Protection Authority didn't have any holiday because they have been recently, issuing very relevant fines. The first one was with Uber, a fine of 290 million, which is huge, and was at the end of August. And then the second one for 30 million to Clearview AI, which, I believe it's a lot to handle in this very small span of time. And it will be even more difficult for you to tell us more about both of them in this Espresso episode. So let's start immediately with the first one, Uber. What happened and what's the fine about?
Well, right when the DPA came back from the holidays, they smacked Uber with a fine of 290 million, which is like huge. It's not the biggest GDPR fine, but it probably makes the top 10. And it's not the first time that Uber was fined. It's actually the third fine. The first time was in 2018, 800K for a data breach. And then in January 2024, we already discussed this a few months ago, 10 million for not responding correctly to data subject access request, and now 290 millions. And this new fine, it was issued because they didn't have sufficient transfer mechanisms. And they didn't have any standard contractual clauses between August 2021 and December 2023. And in August 2021, Uber said, well, we have like Uber America and we have Uber Netherlands, and they are transferring data. And before August 21, they said, well, Uber Netherlands transfers it to Uber USA. Fine, so we need a transfer mechanism, nothing wrong there. And then Uber said, well, no, we are both joint controllers, so that means there's no transfer. So they deleted the standard contractual clauses out of their joint controller agreement. Then in November 2023, Uber got certified for Privacy Shield, and then everything was okay. And now the question is, do you need a transfer mechanism if you are joint controllers? Uber says, no, you don't need it because we both fall under GDPR. So why would you need a separate transfer mechanism here? The European Data Protection Board says yes. They issued some guidelines. The Dutch DPA also says yes. And what the Dutch DPA said, well, you don't have a transfer mechanism, so we will give you a fine. Well, this is something, in the end, the Court of Justice has to decide. But I must say, I find the arguments of the Data Protection Authority and the European Data Protection Board compelling. I believe that strictly speaking, you need a transfer mechanism, even if both joint controllers fall under the GDPR. What I don't agree with is, well, do you need to issue a fine here? Because the question is, doesn't the DPA focus too much on the paper, like the contract, and not too little on the actual protection here? I mean, standard contractual clauses are obviously an important aspect of GDPR compliance. But in this situation, you can ask, well, do they offer really that much more protection? I mean, it's a situation where both controllers already have to comply to the GDPR. So Uber USA is already responsible. So would this contract between Uber Netherlands and Uber USA really make a difference? And after Schrems 2, there was a lot of discussion about, can you comply to this? But Schrems 2 said two things. You first need a transfer mechanism, and you need to take additional measures to guarantee that you have the same level of protection. And these extra measures, these are hard to implement. So the question is, well, do these contractual clauses really make here a big difference? Or is this just an issue of, oh, well, you didn't comply strictly, so we give you a fine? And as with the fine of 10 million, it's once again a very high fine. And the DPA justified this by saying, okay, we could have fined Uber with 1.3 billion, but we give them 290 million, so this is perfectly reasonable. You can once again ask, okay, where's the big harm here in not having a standard contractual clause here?
Thanks a lot, Stephan. I make just 3 quick consideration on what I was hearing. The first interesting thing is that, as you were mentioning, it's not the first fine from the DPA to Uber. So, maybe the fine was not that low because it's not the first time that the DPA fines Uber, not compliant in their view. On the other side, it's also true that it's interesting to see how the authority is looking back to past behavior and not, looking at the present situation. And of course, I understand the struggles for companies to comply with sectors like the one of data transfer, where there have been a lot of back and forth also on the institutional level to better understand which is really the position that each of the companies might take. Of course, probably one company like Uber that is huge, that have a strong legal team, is one of those companies expected to be compliant as soon as possible. But we also see the difficulties of, being compliant 24/7 every day, every time, whenever there are all those changes. So it's very interesting to see your points under both sides. So you understand the DPA, but you also understand the company in some cases, which brings me to the next point, which is what happened with the other company, Clearview AI.
Yeah, about Clearview. Clearview is a company that provides image recognition software to law enforcement agencies. So basically, they scrape the whole internet for images, and then if the police has a video or a picture, they can say, well, this is Alessandro. This is very controversial. It's not the first time that they're fined. Both the Greek and the UK DPA already fined Clearview. But basically, in this case, the Dutch DPA says Clearview obviously needs a legal base to process this data, both for the scraping and for the image recognition. And what the Dutch DPA says, well, Clearview relies on legitimate interest, and their only legitimate interest is the economic interest. They say, well, we have a business model, and this requires this data, so we are allowed to do this. This goes a long way back, because the Dutch DPA always says, well, for the past 3 years, they say, well, economic interest cannot be legitimate interest. And they say, well, there is freedom of enterprise, but this freedom does not include an activity that consists of privacy infringements. So they say, if you have solely a legitimate interest, then you cannot use it as a base. So that's the first infringement, they say. The second is, well, they are using these images to make a biometric profile of someone and then use this profile in order to identify people. Well, this is a violation of Article 9 GDPR. And then there are some minor infringements of the transparency obligations. And then in the end, they come with 30 million fine. What's interesting here is that the DPA already acknowledges that it will be hard to collect this fine, because Clearview is not based in the EU. There have been multiple fines in the past, and I believe that they have not been paid. So what the DPA says, well, this decision first would limit other organizations from using Clearview, because obviously you cannot use such software if it applies illegal processing. And second, they are investigating whether the Clearview board can be held personally liable. And that's also an interesting take.
That's extremely interesting. The one of the enforcement is one of the big topics always related to any data protection regulation, meaning that in many cases, if companies comply, then you need to have authorities with teeth able to provide sanctions. Hopefully and luckily, in many cases, this is not needed, but sometimes it happens, and it's interesting to see how the authorities are already considering an alternative solution to the sanction to see what they can do. Stephan, this was extremely interesting, but as a professional working in the field and working in the Netherlands, which are your key takeaways from those cases?
Well, first of all, the Dutch DPA has awakened. We have had a long period for from 2018 till 2023, where the Dutch DPA was not really active, but now they're showing their teeth. So the Dutch companies, they need to step up their compliance game, because the Dutch DPA shows they're not afraid of fining for past behavior. So many new companies who will face new scrutiny from the DPA. So that's one. The second one is, for the Uber fine, be aware of French taxi drivers. I believe that most French politicians know this, because the fine in January and this fine in August, they are connected. They both come from complaints of French taxi drivers and civil rights groups. And then they complained to the French Data Protection Authority. The French Data Protection Authority complained to the Dutch Data Protection Authority. And what I take from this is that you need to communicate and you need to listen to your stakeholders. If such groups are complaining, don't ignore them, but go and try to find a way to alleviate their grievances, because we know this is like the Dutch and German Rhineland model, but I believe that there's something to say for it. If Uber would have talked to these people, perhaps they could have prevented it. Also, I believe that the time of cry and pray is over. After Schrems 2, everyone said, you cannot really comply to this unless you say, I don't transfer data at all. So a lot of people said, just do it and try to do it as best as possible, and then pray that the Data Protection Authority doesn't notice it. Well, the Dutch DPA shows they're willing to, they're not going to ignore this. So that's very important. Concerning the Clearview fine, it's important to notice that the DPA actually issued guidelines on web scraping for AI. And we discussed these in an earlier episode, and there the Dutch DPA said, this is almost never allowed. Well, now the Dutch DPA shows that they are not going to ignore this. So it's important to take this into account in your compliance program. More on the substance, I would say that the DPA, as I told, they took the standpoint that purely economic interest cannot be legitimate interest. And this is kind of controversial. There is a Court of Justice case pending on this subject, but they changed their argument a little bit here. Before they said, you cannot use it as a legitimate interest because it is not explicitly allowed according to EU law. And now they say, EU law, like the freedom of enterprise, doesn't cover the situation that your business model is just infringed on other people's privacy. So you need to have another interest, and then you can obviously make money. For instance, a company like Meta makes money because they help other people connect to each other. This is not solely economic. And last, I can imagine that the remark about personal liability really struck a note everywhere, because it's something if your company is fined for 300 million, but if you're personally fined, that's another thing as a board member. But I believe that the Dutch law at least has limited possibilities of making board members personally liable. Normally, we respect the corporate feel, and can only be pierced, as they say in the USA, if the board member personally acts very seriously culpable, and that is almost never the case, at least as long as the board has reasonable arguments against this fine. So I believe that it will be very hard to establish personal liability, but so that we're still not there, fortunately, because that would be a game changer if the board of a company would become personal liable.
Perfect, Stephan. Thanks a lot for driving us through not just the two fines, but also the reasoning behind, to better understand not just what happened, but also how your DPA specifically in this case have been thinking about specific topics. And I would really like to thank you for being with us today, together with our listeners. And I very much look forward to see you and all of them together with our next episode. Thanks a lot for your time to you all.